Good morning, everyone. We're ready to get started. Please mute your devices if you haven't already done so, and thank you for joining us here today. Welcome to PERAC's webinar, Chapter 32 in a nutshell. My name is Judith Corrigan, and I am the General Counsel of PERAC. I will be presenting a primer on chapter. Then take a 10-minute break, after which Patrick Charles, PERAC's Senior Associate General Counsel, about death prior to retirement and local options. And finally, Senior Associate General Counsel Ken Hill will speak about what to expect when you are expecting to retire. We will each do our best to answer any question you pose to us via the internet, and we'll do so at the end of each of our presentations. So let's begin about talking about our plan document. Chapter 32 is our plan document, and if we do that, let's talk about the history of our plan. As many of you know, Chapter 32's birthday is January the 1st, 1946, and it was enacted by Chapter 658 of the Acts of 1945. Many plans predated this, of course, but this was the vehicle for standardization of the retirement systems in Massachusetts. A line was drawn in 1945 based upon population. Either you got your own retirement board based on your population, or you became part of a county system. Since then, we have gained some systems, particularly in the late 70s, Minuteman, Blue Hills, etc., and we have lost some systems, such as the Turnpike and Apple. So let's talk about why we have a plan in the first place. Chapter 32 is a defined benefit plan. Federal law requires individuals to contribute to a plan throughout their career. Since Massachusetts public employees do not contribute to Social Security, we have an agreement with the federal government to provide a plan similar to, but in lieu of, Social Security. Before we discuss the elements of a defined plan, let's speak for a moment about a defined contribution plan. These types of plans are currently multiplying and flourishing in a time when traditional pension plans are no longer offered by many companies. Here is what our plan is not. This slide describes the attributes of a defined contribution plan. Sometimes an employer will provide a match, but not for government employees for obvious reasons. Some of the positives of this approach include the employee being able to direct investments, unlimited investment options, and this is portable. You can take it with you to your next job. The types include 401k, 403b, and 457bs. Now, 457bs are the type most public employees would be contributing to if they so desired. 403b is for nonprofits. 401ks are generally for corporations or partnerships. But Chapter 32 is a defined benefit plan, and the next slide shows the characteristics of such a plan. On that last bullet point, you basically can't take any benefits accrued under Chapter 32 with you if you go to work in another state or in the federal government. Teachers are exceptions to this rule in certain circumstances. Many of you know I worked in legal services in Kentucky for 7 years. It was not part of the Kentucky retirement system at that time, although it is now. So if I left here with my nearly 21 years of service and said, hey, can I add my 21 years of service to whatever I earn here? They would say no. Similarly, if I had worked at the Appalachian Research and Defense Fund of Kentucky, or as it's known locally, AppleRed, when it was part of the Kentucky retirement system, if I came to PERAC and said, great news, I have 7 years from Kentucky to add whatever I earn here, they would have said, sorry about that, but no. With that by way of background, let's talk about our current plan and how it works. Chapter 32 is a qualified plan. In regard to that third bullet point, every qualified plan operating under Section 401A of the Internal Revenue Code, which is what our plan is, needs a determination letter from the IRS. A determination letter is a formal document issued by the Internal Revenue Service that indicates whether or not an employee benefit plan has been found to meet the minimum legal requirements for special tax treatment. We really didn't need to produce such a determination letter until EGTRA was passed. EGTRA is the Economic Growth and Tax Relief Reconciliation Act of 2001. What it means to us is this is the first time it was possible to do rollovers in and out of the plan, and financial institutions began asking that retirement systems provide them proof of a determination letter. The IRS, concurrently with this, began a program of issuing determination letters to governmental plans. In 2008 and 2013, all the plans in PERAC banded together to request and receive determination letters which expire after 5 years. However, expiration dates are no longer operative. We all have determination letters which were issued between August the 12th and August 15th, 2014, and all bear an expiration date of January the 31st, 2019. However, the IRS found approval of government plans daunting and has now suspended this program. But on this slide, the last bullet point is key. The expiration dates are no longer operative. So even though the letters you have say they will expire, they've expired as of January 31st, 2019, they have not. This comes about as a result of 26 CFR Section 601-201, Revenue Procedure 2016-37. So I set this whole thing out on the slide so you would have it, and because I believe it's important. This revenue procedure provides that determination letters issued to individually designed plans will no longer contain an expiration date, and expiration dates included in determination letters issued prior to January 4th, 2016 are no longer operative. In general, a plan sponsor that maintains a qualified plan for which a favorable determination letter has been issued and that is otherwise entitled to rely on the determination letter may continue to rely on the determination letter unless a plan is subsequently amended. So, for example, if we had another Chapter 21 of the Acts of 2009 or another Chapter 176 of the Acts of 2011, we would have to submit another determination letter request. Or if a section of the plan was substantially amended, we would have to ask about it. But for the foreseeable future, I think we're all set. I'm very happy we got the last determination letter after Chapter 176. So all 104 retirement systems are a qualified plan. Now let's discuss the responsibilities of both the employee and the employer, and let's start with the employee. Obviously, the employee's main duty is to provide service to the Commonwealth or a political subdivision, and as part of the retirement plan, they pay a certain percentage in the retirement system during each pay period. There are slightly different rates for state police and teachers, but generally, people pay 5% in service on January 1st, 1946, but prior to January 1st, 1975. That's almost 45 years ago now, but as we took this show on the road and asked people if they had any 5%ers, there are still some 5%ers out there, even though the last time you could qualify for 5% was starting service about 45 years ago. You're paying 7% if you started on or after January 1st, 1975, but prior to January 1st, 1984. So that's almost 36 years ago that you could qualify as a 7%er. And again, on the road, we demonstrate that there are a number of 7%ers still in employment. Now, obviously, most of us are either 8%ers or 9%ers. Can people mute their devices if they're able to do so? Thank you. If you started work between January 1st, 1984, but prior to July 1st, 1996, you're paying 8%. And if you are, like most of us, employed on or after July 1st, 1996, you're paying 9%. In addition, if everybody employed after January the 1st, 1979, will be paying 2% on all amounts over $30,000. So when we make our contribution to the system, where does the money go? It goes into the annuity savings fund, where members' accounts earn a princely interest. And it's a rate set by statute, and PERAC issues a memorandum every year to tell you what the rate will be for the year. Currently, it's at 0.01%. The second bullet point, most people are paid regular interest if they voluntarily leave with less than 10 years of service. If they voluntarily leave with less than 10 years, then they are paid 3%, which is more than regular interest, as you can see from bullet point 1. Regular interest is the interest credit to any member's account in the annuity savings fund of any system, or to his account in the special fund for military service credit as provided in section 22, subsection 6. The fourth bullet point, why would an employer have to sign off if an employee seeks a distribution of funds? There are many reasons for this, including whether there has been a charge of misappropriation of funds for Section 15 purposes, or a conviction of a crime related to their office or position, whether a member owes an employer any money under an employee benefit plan, including a cafeteria plan established pursuant to 26 U.S.C. Section 125. So we had a case some years ago where a retirement board asked us to permit them to disperse a member's annuity account without the employer signing off on it. They had tried everything to get the employer to sign, to no avail. PERAC said no, the account could not be distributed. We suggested that the retirement board subpoena the employer and require its attendance at a retirement board meeting. There, the employer could allay the concerns of the retirement board by testifying under oath. The employer refused to appear and said it would neither appear nor sign off on the form. It came to light that the employee had some issues. Perhaps theft was involved, and a deal had been struck to let her take her money out of the annuity account and go on her way. But Chapter 32 doesn't care about deals and doesn't permit deals. So let's talk about whether a loss of all or part of a member's account is possible. To the next screen. This slide, of course, invokes Section 15 and the possibility of pension forfeiture. Ken will be speaking in more detail about pension forfeiture, but right now let's talk about the employer's obligation in regard to the retirement system. The employer's part. Here is the employer's financial contribution to the system. People who say, why do we have the 3/8C reimbursement scheme if the money travels with the employee, don't understand this slide. Any questions about the actuarial basis, of course, should be directed to PERAC's actuarial unit. But basically, you can see here that the employer makes an annual appropriation based upon a funding schedule and the number of employees. So let's discuss funding the systems. The funds of each system are overseen by a retirement board, and the retirement board has a monumentally important role in overseeing the funds of the system. Let's sum it up. The retirement systems are funded by contributions of the members of the system and appropriations from the governmental units whose employees make up the membership, and earning on the investments of the system's funds. So with all this funding, with all this money coming in, let's talk about unfunded liability for just a minute. Until 1988, it was theoretically possible to put money away for the to fund the future, but so many hoops had to be jumped through that not many retirement boards did this. There was a debate when we were making this presentation as to whether to say could not or did not on the first bullet point, but we decided to go through could not because most boards really could not fund for the future. It wasn't possible for them. So here we see that the retirement systems have to have an unfunded liability that must be reduced to zero by the funding schedule, by the dates in the funding schedule. And as noted in slide 15, the payments are made to the system by the governmental entities whose employees are members of the system. So having talked about the important role of the retirement board in the funding and being in charge of the funds of the system, let's talk briefly about retirement board composition, which is pretty familiar to everybody who is listening to this webinar. So you can see there are 5 members of 103 of the 104 retirement systems. Teachers has 7 members. This retirement composition differs a bit for counties, although they still have 5 members. So you can see the first member is a city auditor or an accountant. The second member is the municipal designee. The third and fourth are the elected members. And the fifth is chosen by the other 4. And the fifth can't have anything to do with the town or municipality in which they are, in which they will be sitting on the board. And the other 4 members, all 4 people in attendance, have to select the 5th member. What is this all about anyway? Why do we have a retirement system? Why do we have a retirement board? It's all about retirement allowances. There are generally 4 kinds. Speaking broadly, there are many kinds. There are ones that don't apply to many people or apply to a certain group of people. But generally speaking, these are the 4 retirement allowances your typical employee can expect at the end of a career, or even a career cut short by illness or an accident. So we have superannuation, termination, accidental, and ordinary. Now, when we think about the retirement allowance we're going to receive at the conclusion of our careers, the first bullet point, superannuation, is the one we think about the most, and I dare say the one we desire the most. Because obviously, if you're terminated from your employment, that's not good. If you're hurt on the job, that's not good. And if you become so ill, you can't continue on the job, that's not good. But the termination allowances provided under Section 10.2 are not available to those who became members of a system on or after April 2nd, 2012. That's an important point to make. Termination and the rest of the allowances here have varying criteria. We will look at each of them in turn. But before we talk about that, let's talk about retirement allowances of limited applicability. So we can see here on this screen retirement allowances. The first 5 bullet points affect a lot of people, The 2050 benefit is for corrections officers only. It provides an allowance based on 50% of your annual rate of regular compensation the last year of your work. You have to have worked as a correction officer, actual service as a correction officer for 20 years to get this benefit. And obviously, correction officers have a very difficult job, and this is a way that they try to encourage people to stay in those jobs. Troopers and judges are with the State Retirement Board only, and questions about that should be referred to the State Board of Retirement. And of course, there's an augmented retirement plan for teachers, both in the Teachers Retirement System, Retirement Plus, and in Boston, where the plan is called TARP, Teachers Alternate Retirement Program. The teachers pay more into annuity savings account and are allowed to retire at a slightly earlier age. We won't be delving into this, but I just wanted you to know about the variances of what's out there. Finally, non-contributory pensions. This bullet point might span a bunch of retirement systems. It refers to various non-contributory pensions, including for veterans of a certain age and certain non-member police or fire who get injured in the performance of their duties. Non-contributory allowances are disfavored, and as we learned in an SJC decision issued only last week, Chapter 32 was enacted to make sure most people would be contributing into a contributory retirement system. So with our discussion of limited applicability allowances over, let's talk about superannuation. So this, of course, is based on your age, the amount of years of service you have, your group classification, and your salary average. The salary average is the annual rate of regular compensation received by such member during any period of 3 consecutive or 5 consecutive years for which compensation was the highest. Ken is going to break this down a little more in his presentation. So now an important component of a superannuation retirement allowance is your age factor, which is based upon your group classification. So let's talk about group classification for just a minute. There are 4 different groups. Group 3 is about state police, so we're not going to talk about that today. Group 1, Group 2, Group 4. Your retirement board classifies you in one of these positions. That is required by Section 3(2)G. A retirement board's duty to so classify was upheld in a recent CRAB decision, Newton Retirement Board versus the State Board of Retirement, and Jean Layton versus the Newton Retirement Board. Group 1 is the one we're mostly all in. It encompasses officials and general employees, including clerical, administrative, and technical workers, laborers, and all others not otherwise classified. Generally, Group 2 and Group 4 positions must be listed in Section 3(2)G specifically by job title or less commonly by job duties. We are going to talk next about the fact that there really are 2 different plans, but nowhere, one for people who came on board for April 2nd, 2012, and the others for those who came aboard after that date. But nowhere is that more evident, the difference in the 2 plans, than in group classification. Before, if you retired on the group classification you held at retirement. So if you were a police officer for a month before retirement and a janitor for 30 years prior, you were still going to go out in Group 4. Now, this led to much mischief, and we all remember the story of Mayor Madden, who unfortunately recently passed away, but he was the first mayor of Weymouth, and he was a fire chief for many years, a firefighter and then a fire chief in Weymouth for many years. He went on leave for the civil service, as he is entitled to do so, and became mayor for 2 terms. And when he left his job as mayor, the retirement board put him in Group 4 and retired him. And PERAC said he cannot go out on Group 4. He was not performing the duties of a Group 4 job at the time of his retirement. And the appeals court upheld PERAC's position in that matter. And now I think that a lot of the group classification amendments to the statute have taken place because of Madden, and now employees in Group 2 and Group 4 who wish to use Group 2 and Group 4 as in their retirement allowance have to hold their group classification for 12 months prior to retirement. This is for employees prior to April 2nd, 2012. For those on or after April 2nd, 2012, you have to have prorate. So there is no longer a possibility of the Madden situation coming up again. I'm again going to ask people to mute their phones if they possibly can. We're still hearing people on the line here. Thanks. Okay, so in essence, we have 2 plans. We all know about Chapter 176 of the Acts of 2011. And, you know, the rights are slightly different. It will all, if you have a long career, it will all basically be quite similar. But in essence, we have two plans because of Chapter 176 for those before and after the dates on the slide. So let's talk about each group and how each, how the before and after sets fare. So you can see Group 1, the age factor at age 55 is 1.5, and they could retire at age 55 or older with at least 10 years of service. For the after set, that age is brought up to 60. You have to be 60 or older with at least 10 years of service. But look at that age factor. It goes down. At 60, it's 1.5 for the new group. But if you think that's impressive, wait till you see the Group 2 people who really bore the brunt of this. So before, they could retire at age 55 or older with at least 10 years of service, and their age factor at 55 was 2.0. Now you could retire the same, 55, 10 years of service, but the difference is the age factor. Look at that age factor for Group 2 in the after set, 1.45. And there are some pretty grueling job duties in Group 2, but they're really bearing the brunt of this. Okay. And now Group 4. Now Group 4 is slightly different than the others. As you know, if you retire as a member in service and you are in Group 4, you can retire with less than 10 years of service. The before group could retire at age 55 or older with service sufficient to avoid the triggering of Section 13. Age 55 age factor was 2.5. After, same thing, but with a different age factor. Now Group 4 has to work till age 57 to get the factor of 2.5. But let me talk about Section 13 for 1 minute. Section 13 should not arise anymore. It provides that if you are only going to get an allowance of $360 a year, you can't be paid an allowance. You have to be given the return of your deductions. And if you make if you're going to make between $360 and $599 annually, the member can decide whether to take the money out or get the allowance. It's hard to fathom this section having much impact anymore, and it does not apply to beneficiaries. So under Section 5, to recap, Group 4 does not need 10 years if they reach 55 and retire as a member in service. Again, difficult to say who this applies to, since most public safety are hired at a maximum age of 32. So 55 minus 32. All right, superannuation retirement allowance recap. So there are the age factors, which we've just discussed, but it's on a nice slide for you to look at your leisure. So a firefighter, for example, who dies under age 55 from the on or after April 2nd, 2012 set, no longer will have the benefit calculated at 2.5 for Section 12(2)(d). Firefighters and other Group 4 members will now have to wait until age 57 to get to 2.5, so they are not getting the maximum age factor under either Section 12(2)(d) or ordinary disability retirement, as the statute is currently written. I don't know how much this has come up so far, because when you think about it, now we're 9 years, almost 9 years into Chapter 176. So Patrick will be discussing the death prior to retirement in more detail in his portion of the presentation. And of course, another major difference between the two, the before and after sets, the 3-year to a 5-year average. When I give this presentation on the road, I always say, as long as you hang in there long enough, it's really not going to be that much of a difference in your retirement allowance. But then it was pointed out to me, this will always be a difference between the before and after set. If you hang on long enough and you retire at 67, you're gonna be all right, but you're still going to have your average done at a 5-year average instead of a 3-year average. So that's important to note, and that is, Patrick will cover this when he speaks, but that's also true for his 12(2)(d) calculations. So we've talked about age and group classification. So let's talk about another crucial factor in finding out how much of the superannuation retirement allowance you'll get, and that's creditable service. It's based on the amount of creditable service. And this slide sets out the possible sources of creditable service. Of course, the first one is the easiest one. We get creditable service by our current employment. The second bullet point is the second easiest one, transfers of time from one retirement system to another. And then it gets a little dicey after that, and we'll discuss all of these things. So first, let's talk about transfers, because I think we all have presently employed down pat. When you fill out your membership form upon becoming a member of the system, there is a space for you to write if you have been an employee in another public pension system. So if you're changing jobs within the same county, there's no need to transfer funds, as this will still be in the same system. If the member hasn't already done so, they should inform their current retirement system if there's any potential money in other retirement systems, and the retirement systems will request transfers. This is the easiest way, other than present employment, to earn creditable service. The second bullet point involves the dual member provisions of Section 5(2)(e). As we all know, there were amendments, substantial amendments to this section in 2014. Now the best practice is to transfer now, ask questions later, since 5(2)(e) applies by its terms now to the 5 years of creditable service immediately preceding a member's superannuation retirement. Redeposits. So this slide presents an example of redeposits. This is a member who has taken money out of one system upon terminating employment and then comes back 7 years later. They have 1 year from the date of reentry or reinstatement to buy back the refunded time using buyback interest. If more than a year elapses, they must make the buyback using actuarially assumed interest. It's very straightforward, but this can be painful to the member depending upon the amount of time that has passed, the amount of money they took out, and the interest rate applied. So the last two bullet points on this slide 31, indicate a legislative desire to get the money back into the system sooner rather than later. So let's discuss buybacks of earlier non-membership time. If a buyback is made under Section 4, buyback interest is used. If buybacks are made under Section 3, actuarial assumed interest is used. People buying back non-membership time under Section 3 between April 2nd, 2012 and April 2nd, 2013, or entering into a contract to buy it back in that time frame, were able to use buyback interest to make the purchase. After April 2nd, 2013, all prior non-membership purchases bought back under Section 3 will have to be made at the actuarially assumed interest rate. So on this side, we have Section 3.5 and Section 4.2c. Are those the only two ways you can buy back earlier non-membership time? No, they are not, but they are the two principal ways. Of course, Section 3.5 allows you to purchase the time from prior employment in another system, and Section 4.2c allows the purchase of time from employment in the same system. So they're not the only vehicles for the buyback of non-membership time, but they are sure the main ones. So let's compare the two of them in a column fashion. So, and one constant about being permitted to purchase the time is that the member had to have been excluded from membership by a regulation of the retirement board. And to illustrate the differences between the two types of time, here's a Venn diagram. This Venn diagram is clear how limited purchases under Section 3.5 are. There is a tendency to graft allowable purchases under Section 4.2c onto Section 3.5, but that is not permissible. But this shows the contrast between the two kinds of time very well. So keeping this diagram in mind, we ask how much time needs to be purchased. If I only need 10 years to get to my 32 years, do I have to buy back more than 10 years? So the answer is, if you're redepositing funds, you have to put in the whole amount you redeposited. So if you withdrew 14 years of service, you have to pay back the 14 years of service with interest. Obviously, there's a workaround on this. We'll talk about this a few slides down, but veterans don't have to buy all their military time, and they can buy to a maximum of 4 years only. The buyback of prior non-membership service, you can see that you can buy back less than all non-membership time, but if less than all non-membership time is purchased, the member must purchase the most recent time first, trying to get more money in the coffers of the retirement system. So inactive members. Can inactive members buy back time? This was the eternal question before CRAB issued a definitive decision in Zavaglia. And I think Zavaglia, which was issued in 2015, really made clear, third bullet point, that the ability of an inactive member to buy back service is extremely limited. There are some exceptions to this general rule, and please refer to PERAC Memorandum number 12 of 2015 for more information. There is a big loophole to this, though. I don't know what to call it other than a loophole. The second bullet point up, section 36D, which is the redeposit of funds. You withdraw funds from System A, you return to work in a job in System B, leave the new job in System B, leave your money in System B, you'll be able to redeposit the System A money at any point before a retirement allowance becomes effective for you. So this is inactive members, extremely limited, but if you happen to awaken the 36D loophole, you'll be able to do that up until the time you retire, regardless of whether you're inactive or not. Let's talk about veterans. Patrick's going to discuss local options about veterans in his presentation. As I said earlier, no interest on payments. Bullet point A assures the highest payment to the system. Bullet point F is particularly of benefits to those veterans going out on ordinary. So now a person, as the law is currently constituted, could buy back 4 years of military time after they have 6 years of service and be eligible for a superannuation or a ordinary allowance. But as you know, the veteran's ordinary is a yearly amount of pension equal to 1/2 of the average annual rate of his regular compensation immediately preceding the date his retirement allowance becomes effective. So that could be a real benefit to veterans. And sometimes it happens that a veteran would get more money going out the other way under superannuation, and of course they should do whatever gets the most funds for them. Termination allowance. You have to be a member prior to April 2nd, 2012. The third bullet point, discharge from a position without moral turpitude on his part. The definition of moral turpitude is elusive. We had a DALA case recently that was overturned where somebody was denied a retirement allowance because they had moored their boat without rent, and it was overturned at CRAB. But Black's Law Dictionary defines moral turpitude as, in general, shameful wickedness, so extreme a departure from ordinary standards of honest, good morals, justice, or ethics as to be shocking to the moral sense of the community. It also has been defined as an act of baseness, vileness, or depravity in the private and social duties which one person owes to another or to society in general, contrary to the accepted and customary rule of right and duty between people. So we can see that's a pretty high standard, but you have to be discharged without moral turpitude on your part. So let's talk about the other Section 10. Remember, there are two different kinds of Section 10 retirements. On the previous slide, we told you about Section 10.2, the termination retirement allowance, which has certain criteria and is subject to PERAC review under Section 21(1)(d). The next slides are about Section 10.1, which permits Section 10 to be used as a superannuation retirement vehicle if certain conditions are met. So Section 10 is any member classified in Group 2, 1, 2, or 4 who, after completing 20 or more years of creditable service, resigns or voluntarily terminates his service or fails of reappointment. Section 10.3 involves deferred allowances, permitting you to get your allowance after you have left service. So let's talk about Group 2. Or did I talk about Group 1? Sorry. Group 1, the before group could retire at any age with 10 years of service or more.
I think we talked about last night. Okay.
Everybody mute your phones, please. Okay, and then the second one is you may retire with 10 years or more of service at age 60 or above.
So,
Group 2.
the recon of the
Column 2. They can still retire at 55, but there has been a reduction in the age factor, as we previously noted. At 55 years, new members of Group 2 will be at 1, 4, or 5 as an age factor. And Group 4, you may retire at any age with 20 years of service or more if you're in the before group, or retire at 10 years or more service at age 50 or above. So that basically sums up the non-disability retirements. So there are two types of disability benefits.
Did you send that? I can't see.
So somebody's talking out there in the world, and you need to mute your phone because we can hear it.
Thank you.
Okay, thanks. All right, so there are two types of disability benefits, accidental and ordinary. They're offered by our plan, and you can see the comparison between the two on this slide. After a quick comparison, you can see that the accidental disability retirement is a much better benefit than the ordinary disability benefit and far more sought after. So let's talk about the two types. So PERAC reviews all disability retirements, accidental death allowances, and termination allowances approved by the retirement boards. So the first, accidental, is for those with a job-related injury, and ordinary is for those whose illness or injury is not related to the job. And this can just come down to fate. I remember reading a disability once about a woman who was injured at a conference in Florida. And throughout reading it, I said, why is she not getting an accidental as opposed to an ordinary? Well, it turned out she had taken what would be referred to in workers' comp as a frolic and detour, and her family and her had gone to Disney for an outing, and she was injured leaving that park. So she was not eligible for accidental. If she had been going from one place, she had a job obligation at the conference to another place, would have been covered. Another time, there was a firefighter who was really grievously injured in a skiing accident in New Hampshire, and another firefighter who was injured on his job as a carpenter. So sometimes this just comes down to fate. Sometimes it's hard to understand why people would go for an ordinary as opposed to a superannuation, but we're told there's a lot of benefits in the world if you say you're retired for disability. But remember that usually, unless you're a veteran, an ordinary will be the same amount as an accident, as a superannuation if you're over the age of 55, and the ordinary subjects you to all sorts of earning limitations, the CME, the RTS process. But the ordinary is taxable, ADR only taxes the annuity. The benefit to an ordinary is the age factor bump up unless you're a veteran. So it's probably fair to say that most people, except for veterans with a small amount of service, would not choose to go out under ordinary unless they absolutely had to do so. So the criteria for an award of an ordinary disability retirement benefit, assuming that the minimum service requirements have been met. The minimum service requirements are 10 years for vets, 10 years for everybody in all but 3 boards, and those 3 boards require 15 years. Originally it was 15 years, then a local option was introduced to allow it to be 10 years, and everybody but 3 boards has accepted that. Just like with an accidental disability retirement, the ordinary disability retirement applicant must be examined by either a joint panel or 3 separate physicians. For the ordinary, the physicians must find that he or she is incapacitated from performing the essential duties of his or her job and that the incapacity is permanent. With that certification, the board, considering all medical and non-medical evidence, including length of service, may grant an ordinary disability retirement allowance. As mentioned earlier, if it's granted, it's subject to PERAC's 21(1)D review. And there are some terribly sad cases under ordinary disability retirement. And equally sad are people that are hurt on the job. And this is accidental disability retirement. For this one, the physicians must also certify that the member's inability to work was brought about as a result of and while in the performance of his or her duties at some specific time and place. As mentioned earlier, if it's granted, it's subject to PERAC's 21(1)D review. A disability may not mature after you've left service. So you have to be disabled as a member in service in order to get this benefit. There's an exception about the cancer presumption. I won't get into that right now. Involuntary retirement. There's a lot of misconceptions about this one. Involuntary superannuation retirements are disfavored. Some retirement boards won't entertain them, and PERAC supports this lack of entertainment. A forced benefit based on age alone is going to raise the specter of age discrimination from a federal government standpoint. It's more difficult to get an accidental or an ordinary because the underlying criteria must be met, but it's probably a better idea to do so. If someone is not disabled and just a horrible employee, they should probably just be fired for cause. Why use Chapter 32 as a vehicle to resolve employment disputes? But people do it all the time, but they shouldn't. So I need to find out if there's any questions. I don't know if any questions have been answered, have been asked for my. Are there any? Okay, there are no questions. Apparently I gave such a stunning performance that nobody has any questions left after I'm completing it. So this concludes the first of our 3 presentations this morning. We will now take a 10-minute break, after which Patrick will begin his presentation. Thank you for your attention.
Good morning, everyone. I'm Patrick Charles, Senior Associate General Counsel here at PERAC, and I'm going to be doing a 2-part presentation this morning, a very brief overview of what happens when a member dies prior to retirement and what benefits and options are available to the beneficiaries. And also then I'll go into some local options which are available for retirement boards to choose from and to either enhance or improve certain benefits at the local level, not on a global Chapter 32 scale. There are certain statutory provisions that come into play when a member dies prior to retirement. There are 4 main sections that I will discuss. This is an overview, and I will not cover every conceivable scenario that can happen. As we know, people can die in various ways, different situations. I cannot cover every possible one, but there are some basic rules that will apply, and that must be analyzed when looking at a member that dies prior to retirement and what benefits are available. 4 sections that we're going to examine are Section 9, Section 11, Section 100, and Section 12(2)D. There's also a Section 100A, which will take up a very small portion of one of the slides. And as I said, in the second part, we're going to look at local options. But let's get right into the 4 sections for death prior to retirement. The first one is Section 9, which deals with an accidental death benefit. This can be when a member dies in service as a result of and while in performance of his duties. It can also be applied to a person who has already previously retired for disability. Most commonly, we see a Section 9 after a disability with regards to presumption. A police officer goes out under the heart law, 10 years after retirement, they die as a result of a heart attack. They would then, Section 9 would then be available to them, even though they were no longer in service when they died. But because their disability was based on the heart law and they died subsequently for the same issue, they would be eligible. And when a member dies while in the performance of their duties and they are the beneficiary gets the Section 9, then all sums credited in his annuity account are immediately dispersed to the beneficiary. Surviving spouse will receive a pension equal to 72% of the member's annual rate of compensation on the date of death. If a member is already retired under accidental disability, then the benefit would be not less than the pension portion of the member's retirement allowance that the member was receiving at the time of their death. We'll also see the Section 9 come into play when a Section 100 is at issue as well, but right now, the Section 9 is for when a member dies in service as a result of the duties or dies after service, after retirement for ADR, for the same cause for which they were retired. Section 11 deals with the return of accumulated deductions, and when a member dies, this may result in the beneficiary being entitled to return of the member's annuity account. This is going to come in where the proper forms being used is important, and the advice to the members when they sign up for the system is going to be important, because they need to designate a beneficiary or beneficiaries on the proper PERAC form. Under a Section 11, beneficiary can be virtually anyone or any entity. It is a taxable event if it is withdrawn by the member. So you can also have a Section 11 where members just simply leave service after 5 or 6 years and decides to withdraw their account. But in our situation here, we're dealing with if the member dies and the account has to be dispersed because of that death, it would go to the beneficiary of record. If the member dies without a survivor beneficiary eligible for benefits under another section, then deductions will be paid to the beneficiary listed on the PERAC form. As I said, you can have multiple beneficiaries. The only real requirement is that the total must add up to 100%, and you can name anyone. If there's no beneficiary listed, so if the member never fills out a Section 11 beneficiaries form, then the board can determine who should get the account if it has less than $300. So this would be a very, very short-term employee or a very low-paid employee. Otherwise, the deductions are paid to the member's estate. The next section is Section 100, which deals with the killed in the line of duty benefit. And this is only available to certain named employees. They have to be police officers, firefighters, or corrections officers. And death under certain conditions triggers this section, which pays 100% of a member's salary to the surviving spouse. A spouse is required for this section. However, if there is no spouse and a child is a possible beneficiary, then that child without the spouse is limited to 72%. And basically, they get the benefit actually under a Section 9, not a Section 100. You'll see at the bottom, there's just the Section 100A reference, and this is a killed in the line of duty benefit. And this is a $300,000 lump sum payment to public safety officers killed or sustained injuries which were the direct and proximate cause of their death during an incident, accident, or violence. So the one big caveat with Section 100A, and this does come up frequently, is presumptions cannot be used to satisfy the requirements of Section 100A. They are very specific what types of injuries and how the incidents must occur. So, for instance, a firefighter spouse receives a pension benefit if the firefighter dies or sustains injuries which result in death while in the performance of his or her duties and as a result of an accident while responding to or returning from an alarm or fire or any emergency, result of an accident involving a fire department vehicle which the firefighter is operating or riding, or while at the scene of any fire or any emergency. A police officer's spouse would receive the benefit if the officer is killed while in the performance of her duties or as a result of an assault on his or her person or an accident involving a police department vehicle that they are operating or riding. And a corrections officer would receive the benefit if the officer is killed or sustains injuries which cause the death as a result of an assault on his or her person while in the performance of his or her duties. So there are very specific criteria that must be met before a Section 100A would come into play. The fourth section is the 12(2)D, which is commonly referred to as the Option D allowance. It's known as the Member Survivor Allowance, and this provides a beneficiary with the allowance the member would have received under Option C as if they had retired on the date of their death. The calculation will depend upon the date of entry into service, and in the next few slides, we're going to see how whether you are a member prior to April 2nd, 2012, or after that date, can really change the benefit that would be available under Section 12(2)D for the beneficiary. That's because Chapter 176 of 2011 made significant changes to the statute, in particular to the age factor that is used for calculating a benefit. So this slide just lays out the Group 1 benefit under 12(2)D. And if you'll look, you'll see the age factor on the bottom of each side of the slide. Age factor 55 is a 1.5 if you remember prior to April 2nd, 2012. And it's a 1.45 because you use the age at 60 under April 2nd, after April 2nd, 2012, folks. And that's because the retirement age has been moved from 55 to 60 for Group 1 employees under Chapter 176 of 2011. So if the member dies before the age of 55, then the benefit is calculated at the age of 55 for the pre-2012 members, but you would use the age of 60 for the post-2012. Now you'll see here, and I believe Judith mentioned this in her part of her presentation, dealing with the age factors. You'll see here that the Group 2 people are dramatically impacted because they still both use the age of 55, but the age factor at age 55 for a Group 2 person is dramatically different if you were a pre as opposed to a post-2012 member. If you look on the left side, you'll see that the age factor at 55 for a pre-2012 is a 2.0, but for a post-2012, it's a 1.45. So it's basically the same benefit that a Group 1 member would be getting. So being in Group 2 does not benefit someone when it comes to a 12(2)D if you are a post-April 2nd, 2012. And the last slide deals with Group 4, and here you'll see that there is still a difference because the pre-2012 people, the age factor for their retirement is a 2.5 at age 55 under Group 4, but it's only a 2.2 at 55 because the maximum age for Group 4 was increased for post-2012 people, and instead of reaching maximum factor at age 55, it's now 57. But it's not as drastic a change as Group 2. So now we'll go into the second part of my presentation, which is dealing with the local options. So one of the good things about Chapter 32 is the fact that Chapter 32 is uniform from system to system for most instances. So if you work in Boston, the way your benefit is calculated is the same as if you work in Pittsfield. However, there are some distinctions that can be made at the local level by the retirement board, by the local elected legislative body, to increase certain benefits or to provide certain benefits that are not normally available. We're going to cover a number of them, increasing the member survivor minimum allowance, the idea of Group 4 for EMTs, board member compensation, a COLA increase, supplemental allowance for dependents, and also the surviving children of accidental disability retirees, and the Section 101 benefit, And then there's also a local option for veterans, disability retirees, and also something that's not an enhancement of benefits, but remote participation, which is an option that is available for the local retirement boards. The first thing I want to mention before I even get into this section is that what I hope that everyone gets out of this part of the presentation is not necessarily that you remember everything I say about each individual benefit, but that you walk away from this and go back to your local board and evaluate which benefits have been adopted at your local system and decide and have a discussion about whether you want to adopt any of these local options. I can tell you that since we began giving this presentation about a year ago, we've had almost 10 boards that have adopted certain individual ones of these, and they have oftentimes credited the fact that we presented them with this option during this part of the presentation. So the first benefit is the member survivor minimum allowance, which is the part of the 12(2)D, and it provides for a minimum survivor allowance to a spouse when a member dies in service and the member has at least 2 years of creditable service. The spouse, you must have been married for not less than 1 year, and member and spouse must have been living together at the date of death unless the board finds that they were living apart for justifiable cause. I will tell you that most often justifiable cause would be because the spouse, the member, was incapacitated in some way. Oftentimes it's that they were in a hospital or in a nursing facility or some sort of rehab facility, and that's why they weren't living together. They may have been in a long-term care facility at that point. The survivor allowance is traditionally or technically $250 per month unless the local option is adopted. The local option increases the benefit to $500 per month, pardon me. Now, this would be voted on at the local legislative body. So in a city, the city council, in a town by town meeting, and in a county, it would be done by the vote of the County Retirement Advisory Council or the Regional Retirement Advisory Council if it's a regional retirement system. If there's a district, it's the district members or a vote of the governing body of an authority if they have their own retirement system. And if you look at the slide, the last sentence says acceptance shall be deemed to have occurred upon the filing of a certification of such vote with the commission. When you adopt some of these local options, that language will be included, and that means that you must notify PERAC that you have done it. Otherwise, it is not officially in place, and the benefit is not properly paid if we are not notified of the adoption. Right now, about half the systems have not adopted this, this provision. The next local option is Group 4 for EMTs, and this is a local option that has not been approved by very many retirement systems or towns. One thing to note is if you are a county retirement system, it's not the county retirement system or regional retirement system that adopts this local option. It is the local city or town. So if you look on our website, you'll be able to see every local option that is adopted. And you can click on each local option on our website, and it'll give you a list of all of the systems, and it'll say yes or no next to them. If you look at a system like Bristol County, it's going to say yes next to them. Bristol County as a whole has not adopted this. Only one of the towns in Bristol County has adopted it. So that one town's EMTs are in Group 4, but all the other EMTs would be in Group 2, I believe, for those other towns. Currently, Group 2 specifies that ambulance attendants of a municipal department who are required to respond to fires and perform duties assigned are in Group 2. The Group 4 local option applies to uniformed employees who are certified as EMTs. So there's 4 systems that are listed, 3 board systems that are adopting it, but it's only really 4 communities because it's Boston, Fall River, and Bristol County. What I have learned is that many of the systems and many of the cities and towns in the Commonwealth do not have dedicated EMTs. What they use is firefighters who are certified as EMTs. And so those firefighters are already in Group 4. So it may be for many of your local systems that this is really not an issue because all of the people that are performing the duties of an EMT are already in Group 4 because they are firefighters. But this is adopted in the same way with the city council or the local legislative body. The next section is Chapter 32, Section 20, Subdivision 6, which deals with board member compensation. So board members can be compensated at not less than $3,000 and not more than $4,500 per year. And there are some board members also, like the treasurers, when they're on a board, there's another provision for them to be compensated, but their total compensation cannot exceed $4,500. There are some systems that board members are not compensated, but a system through the local legislative body can adopt a salary of between $3,000 and $4,500 if they so desire. That has to actually be done at the legislative level, not at the legislative body level, not actually at the retirement board level. The next item is COLA base increase under Section 103. This is one of the ones where we see the biggest range of not only adoption, but also the amount adopted. So the COLA base is set at $12,000, but it can be increased in $1,000 increments by the local retirement board with the approval of the local legislative body. State and teachers are not covered by Section 103 because their provisions are covered in a different section, and their local legislative body is the legislature, so the legislature sets the COLA for them. But all the other local systems, city, town, and county, they can do so under Section 103. You must file a copy of the vote for the COLA increase with PERAC, and this filing serves as the effective date. Once a COLA base increase is adopted, it cannot be revoked. So we've seen a number of bases from between $13,000 and $18,000. We actually have 5 systems right now that are at $18,000 and a number that are somewhere lower than that, but above the $12,000 base. Supplemental allowance for dependents of accidental disability retirees, or the Section 72A3 benefit. This provides for a $312 benefit for a surviving unmarried child under the age of 18 or 22 if they are a full-time student, or if the child is an incapacitated child, and there is a local option that allows for the increase of that $312, and it's increased by a COLA, which is determined by the PERAC actuary every year. And currently, for 2018, that benefit was increased from $312 all the way to $924.60. There were 4 systems when I first did this presentation that had not adopted the supplemental allowance, but one of them has subsequently adopted it, so now there's only 3. I'm not going to name the others because since this is a webinar and you can watch it or listen to it 6 months from now, hopefully those other 2 or 3 will not be on the list anymore, so I don't want to name them. There's also an increased disability surviving children of accidental disability retirees under Section 9. And it's the same thing. It's currently set at $312, but if this local option is adopted, then the same rate that applies for the Section 72A3 benefit would go to this Section 9 benefit as well. And it's the same child, it's unmarried, under the age of 18, or if they're a student, they can still be under the age of 22, or an incapacitated child. More than half of the boards have not actually adopted this increase, so that's one that I think that you might want to look at. It's entirely possible that some of the boards that I've spoken to have said that they didn't adopt it because they've never even had the situation come up. They have very small systems and they haven't had this issue before. The next is increasing Section 101 benefits. This applies to disability retirees who retired prior to November 7th of 1996 because they could not select an option C benefit. So prior to that date in 1996, disability retirees couldn't choose anything other than option A or B. And so the minimum allowance was put in, which is $6,000 if that person died and left a surviving spouse. This benefit is still available to newer members in limited circumstances, and that would be if the member wasn't married at the time they retired. They obviously wouldn't have chosen an option C to provide a spousal benefit if they weren't married, but they got married subsequent to retirement, then this benefit would be available. And there are actually two local options contained in this slide. You can increase the benefit from $6,000 to $9,000 or $6,000 to $12,000. There are a number of systems that have adopted the 9 but not the 12. You do not have to go in increments. You do not have to adopt the 9 before you adopt the 12. You can simply skip right over the 9 if you're still at the 6. There are currently 2/3 of the boards have not gone to 12, but a number of those 2/3 are actually at the 9 right now. We actually just received one from a board on Monday in the mail, increasing it from the 9 to the 12,000. The next benefit local option is a disability retirement benefit for veterans. I first want to give you a quick overview on some of the things, because in order to qualify for this benefit, you have to be a veteran, and it's important to know who is a veteran. So a veteran has to have 180 days of active military duty in one of the main armed forces, the Army, Navy, Marine Corps, Air Force, or the Coast Guard. They can also be certified as a veteran if that person has 90 days of active duty, as long as one of those was wartime. If you look in Chapter 4, Section 7, Clause 43, you will see a list of all of the military engagements that qualify as wartime service. So there is a very specific period, for instance, for Vietnam veterans. In order for the 90-day provision to apply, the person must have active duty during those specific provisions. However, there is also, if you look at the last part of it, there is a Persian Gulf conflict, which began in 1991, and it requires an act of Congress before that date ends, before that wartime service ends, and that act has never been passed by Congress. And so technically, under the Massachusetts statute, anyone who serves after 1991 is in wartime service. And obviously, you'll probably see a lot more veterans over the last 15 to 20 years because of the war on terror. We see a lot of Iraq and Afghanistan veterans. The one other caveat, this will also apply to not only to the active people in the 5 main branches, but it will also people in the National Guard or the Reserves. However, those people must qualify as a veteran with activated status for at least the 180 days or the 90 days, one of which is wartime. And active duty for training, excuse me, does not count. So you'll often get a DD-214 from a member who joined the reserves, spent 6 months at active duty training, and then they were in the reserves for the next 10 years and were never again activated. They are not a veteran. They must be activated under Title 10 or Title 32 of the Federal Code. Active duty for training does not count, as it is specifically excluded for the definition of veteran. So as you'll see here, Chapter 157 of the Acts of 2005 put in place 2 local options. The first is to give the $15 per year for every year of creditable service up to $300 for veterans who are in Group 1, 2, or 4 and retired for, it should say accidental disability. This is the same benefit that is available to superannuation retirees who are veterans, but for years only the superannuation retirees were eligible for the $15, the $300 veteran bonus. It was not available to disability retirees. The reason I say it should say accidental disability retirees is because ordinary disability retirees do not get this benefit. because they are already receiving most likely an enhanced retirement benefit because an ordinary disability veteran gets 50% automatically. The second provision is the retroactive payment of veterans benefits, which goes back to the date of retirement. In this case, we have only 8 boards that have not adopted the $15 a year for disability, for accidental disability retirees. But actually, I believe one of those has also recently adopted it. But the retroactive payment one has not been adopted by very many systems. And I don't think that this will be adopted by a lot of the systems, because since it clearly states that it goes all the way back to retirement, you've had 14 years since it was put into place, so that's 14 years of payments plus however long before that some of these people were retired, which could add up to a sizable sum. So we have not seen anyone adopt this in a number of years. The last local option, which is not a benefit related, but it is relevant to the running of the retirement system, and in particular how the board meets, is the remote participation provision. So a local retirement board can vote to adopt remote participation, meaning that not all of the members of the board need to be present at the board meeting for it to be a valid meeting. This is done by a simple majority of the board voting to allow remote participation. Certain rules apply if the board adopts remote participation. Most importantly, all votes must be by roll call, and also you must still have a quorum of the board present at the meeting. So if with a 5-member board, you have to have 3 members in the room meeting in order for 2 to participate remotely. When remote participation was first put in place, you needed to be very specific about the reason why someone was participating remotely. You no longer need to do that. You can simply, at the beginning of the meeting, the chair should announce who is participating remotely and basically state they are participating remotely because they were unable to attend the meeting. That's all that you need to do now. There's much more detailed information under the Attorney General's regulations at 940 CMR 29. And they also, if you go on the AG's website, they have a very good and extensive outline and frequently asked questions section that could answer a lot of questions about this. The board, we asked that the board should notify PERAC that they have accepted this. This is important in particular to make sure that when we are checking and seeing that an action was taken by a board, that the vote was done properly. And there are some requirements for recording all the votes as roll calls in the minutes, and we can then see that that is all done and valid if we know that the board has accepted the remote participation. And in conclusion, one of the best attributes of 32 is that most of its provisions are uniform from system to system. However, there are ways that you can differentiate your system from another and provide an enhanced benefit via these local options. There are a number of other local options which I did not cover that are very specific to various groups. I would advise and ask that each board member and administrator take a look at our website. There's a local options page, and it will list all the local options, and you can easily check to see if you have adopted these. Some boards have adopted these years ago, so you can then see, and most importantly, please do this so that you can notify us if we are in fact wrong. We have had a couple of situations where our website did not have the up-to-date information, and this helps us keep that information up to date if you could notify us of that. And that concludes the local options section. I will then switch over to Ken Hill, another Senior Associate General Counsel.
Good morning. As Patrick said, my name is Ken Hill. I'm going to be presenting today on a presentation called What to Expect When You're Expecting to Retire. This presentation is intended to serve as a sort of cheat sheet that covers some topics that soon-to-be retirees likely should know. In preparation for this presentation, I had polled and talked to several administrators, and I'd asked them what are some of the areas that surprise recent retirees. You know, the ones where someone retires, then they come into the office and say, no one told me that. You know, so that's what I'm hoping to address here. Hopefully I hit some good topics within this presentation, and you know, ideally this is designed so this could be a presentation you could actually refer some of your soon-to-be retiree members to, and hopefully it will answer their questions before they have to bother you. I'm not sure if retirees will necessarily care about this, but a retirement allowance is made up of two parts. Okay? The first part is the annuity, and the annuity is basically the amount that a member contributes during their career, plus interest that accrues on that. And once someone retires, the annuity account gets depleted and gets lower every month. The second part of a retirement allowance is the pension portion, and this is the portion that basically makes up the difference from the annuity and the retirement allowance. Oftentimes, however, people refer to the entire amount, the entire retirement allowance, as the pension. Now, the difference in the annuity and pension can be notable at times, and I'm going to actually mention it later on in this presentation a few times, where the differences do matter. There are three retirement options that are available to members. They're available to all of the retirement categories, and those include superannuation, termination, and accidental and ordinary disability retirements. A person's choice of an option can depend on a variety of factors. Their age, their health, their spouse's age, and their spouse's health. The choice is up to the member. The only caveat is that Chapter 32, Section 12(1) states that if the member is married, the board must provide the member and the spouse with detailed information about the options, and it requires spousal acknowledgement of the option selected. Now, it's acknowledgement by the spouse. It does not require spousal consent. There have been situations where a spouse claims that the retiree forged his or her signature. In that event, the board can make specific findings of fact of whether it was indeed a forgery. And if the board finds that the acknowledgement was invalid, the default option is automatically an option B, which I'll discuss in detail later. For now, though, option A. This is the simplest to explain. What occurs here is the retiree receives their retirement allowance until they die. Okay, the option A is also known as the life annuity. The only exception is that a member's estate will receive a prorated payment for the number of days they live in their final month. Option B. An option B benefit is generally 1% to 5% less than an option A benefit. The benefit is paid for the lifetime of the retiree. As I said, it's the default option if they're in the event of fraud or if there's no record of the member's choice. It automatically goes to an option B. With an option B, a member's annuity count gradually decreases after they retire. Generally, and again, this is generally, the annuity account is depleted sometime between 10 to 12 years after a member retires. Once the annuity account is depleted, the retiree continues to get their full retirement allowance, however, because the pension portion increases. So why would someone choose option B? Okay. In the event that the retiree dies while there is money in their annuity account, okay, that money in the annuity account is distributed to a named beneficiary in a one-time lump sum. Now, recently we actually had an inquiry about this. Okay. There was a gentleman who passed away, and he named his son as his option B beneficiary, and there was money left in the annuity account, and the board wanted to, give the son his owed lump sum payment. The son was in college, and he asked for the board to please spread it out over a period of 5 years because it would have affected his eligibility for some financial aid. We were consulted on it, and believe me, the legal department, we all have tremendous student loan debt. So we definitely sympathized with the young man. However, Section 12 specifies that it must be a lump sum. So we directed the board to give that young man the lump sum payment. We were also a little concerned about any federal tax implications with this. Now, who can be named an Option B beneficiary? Quite simply, any person, place, or thing can be named a beneficiary. It can even be split amongst several beneficiaries. It just needs to add up to 100%. And it can be changed at any time prior to death. So the beneficiary on an Option B can be changed post-retirement. That brings us to the third option, Option C. This is known as the Joint and Last Survivor Allowance. With Option C, you must name a beneficiary. Okay? The amount of the benefit that the beneficiary would receive depends on the life expectancies of the member and the beneficiary. Generally, the Option C allowance that someone would receive in a retirement benefit is 7 to 15% less than in Option A. So why would someone choose Option C? Well, upon the retiree's death, the named beneficiary will be paid a monthly allowance of 2/3 of the Option C allowance for life. So for instance, if the retiree is receiving a monthly benefit of $999, upon that retiree's death, the beneficiary, for the life of the beneficiary, would receive $666 a month. Now, who can be named an Option C beneficiary? Unlike Option B, Option C's choices are very limited. First of all, you can only name one beneficiary. Okay? You cannot split the Option C. This is because the benefit is based, in part, on the age of the beneficiary. So you can only have one. Second, the beneficiary can only be a spouse, a parent, a former spouse who is not remarried, a sibling, or a child of the member. And that's it. Third, the eligibility of the beneficiary is determined at the time of retirement. So a former spouse may remarry after the member retires, and that former spouse would still be eligible. Unlike Option B, the beneficiary cannot be changed after retirement. Okay, so you retire, you name your beneficiary, you're stuck with that beneficiary. Now, what happens if the named beneficiary dies before the retiree? This is in a post-retirement setting. Well, the member's allowance would pop up to an Option A, and the retiree will get an Option A for life. No new beneficiary is named. Okay? It just becomes an Option A. We had a recent dollar case that came to our attention. It involved a woman who married later in life. She retired just a few years after she married. She named her new husband her Option C beneficiary. Very soon after she retired, they got a divorce. She wanted to change her option to an Option A, saying this isn't fair. You know, I've worked my whole life. I was barely ever married to this guy. The board said, unfortunately, you cannot change your option, or you cannot change your beneficiary under an Option C post-retirement. She appealed that to the Division of Administrative Law Appeals. The dollar magistrate sympathized with her, but he denied her request. You cannot change your option selected or your beneficiary after retirement. The magistrate did note, however, that essentially said, well, hopefully you'll outlive him, okay? He'll die before you, he won't get anything, and your option will pop up to an A. So she's got that to look forward to. Okay, moving away from the options. As I said, I spoke with several administrators about some issues that they deal with new retirees. And one thing had to do with the fact that retirement allowances are paid on the last day of the month. Okay? It's important to let them know that so they don't expect a check right away. You know, they're used to getting their biweekly paycheck, and then all of a sudden, you know, they may have to wait a month or longer, okay, depending on the size of the board, to get that first check. I would encourage you to encourage these soon-to-be retirees to prepare to cover any gap in time that they may have. I know it's not easy to do, but I think if you make people aware of that, then, you know, you're helping yourself. Taxes. Any conversation you have with a soon-to-be retiree about taxes should start with the phrase somewhat like, we are not tax experts, okay? But just with basics about it, superannuation retirements are subject to federal income tax, but not Massachusetts income tax. Ordinary disabilities are treated like a superannuation for tax purposes. Accidental disability pensions, however, the pension portion is not subject to either federal or Massachusetts tax, but the annuity portion is subject to federal income tax. Post-retirement earnings and hours. And this is a deep dive, or in some other presentations that we have, but in brief, no public retiree may work more than 960 hours for a Massachusetts governmental unit in a calendar year. Okay. It's also limited, so it's obviously limited by hours. It's also limited by compensation. And the limitation on the compensation is that the compensation, when added to the retirement benefit, cannot exceed the salary being paid for the position from which he or she retired, plus $15,000. Although the $15,000 will not be added into this formula until at least one calendar year following retirement. Post-retirement earnings for disability retirees. This employment is limited with any employer, okay? So with just a superannuation retiree, you're limited with Massachusetts governmental units. If you're a disability retiree, you are limited with any employer, okay, public or private. The compensation that you can earn when added to the disability retirement benefit cannot exceed the salary being paid for the position from which he or she retired, plus that $15,000. And they do not have to wait that one calendar year for that $15,000. Disability retirees are also required to annually file a statement of earnings. And failure to comply will result in the termination of their benefit. Okay, this is very important, okay, because once they comply, their benefit gets reactivated. But because it was terminated, they're not eligible for a retroactive payment for that time during the termination. That's different than a suspension of the benefit. Okay, so the board members I spoke to said it's very important to get that information out there. Social Security can also be an issue. Okay, as you know, public employees in Massachusetts do not contribute to Social Security. Many public employees previously worked in the private sector, however, and contributed to Social Security. There are two Social Security provisions that soon-to-be retirees should be made aware of. The first is the windfall elimination provision, or the WEP, and the other is the governmental pension offset, the GPO. Now, back at Macris in the spring of 2016, Hank Kim, who is the executive director and counsel to NCPERS, he gave a fantastic presentation on the WEP and the GPO, okay, and he explained what those provisions are and how they affect public employees. At the time, I understood it. Now, my memory of it is not so good, but I recommend you try to Google it. I also recommend that you say, we're not Social Security experts, but here's a little brief on it. The windfall elimination provision, okay? Basically, Social Security is weighted to provide a higher percentage of Social Security benefits to the low earners. Now, because mass public employees do not contribute towards Social Security, it appears that those who previously contributed are low career earners. Well, the WEP is designed to prohibit this, and it lowers such a retiree's Social Security benefit. Now, keep in mind, the retiree's Chapter 32 retirement allowance is not altered in any way. This is a Social Security matter, okay? But again, it's something that many employees, especially the ones who work in the private sector, should be made aware of. The other provision, the GPO, is designed to lower a Social Security benefit that someone may be entitled to because of their spouse, okay? The GPO requires that the Social Security dependent spousal benefits be offset by 2/3 of the Chapter 32 pension, all right? Again, it's a Social Security matter. Refer them to the local Social Security office if they have a beef with that. The retirement allowance that they receive from your board is not affected by this. Disability retirees returning to service, okay? Sometimes a person retires due to a disability, and then they want to and they're able to return to work. Section 8 contains the blueprint for a disability retiree to return to service, okay? Of important note, a vacancy must exist in order for the person to be rehired back. When someone returns to service under Section 8, they're entitled to creditable service for the time they were a disability retiree. Reinstatement. Okay. Superannuation retirees should be cautioned about being certain that they want to retire. Okay? The reason being is because getting reinstated is a very difficult and onerous process. Section 105 provides the blueprint, although I will say it's not exactly the clearest blueprint I've ever read. Okay? But essentially, in order to be reinstated, okay, a retiree must waive their pension. They must pay back to the retirement system every dollar he or she received in a retirement allowance with buyback interest. So the longer someone's been retired, the more of a benefit they would have received, the more they have to pay back. Okay? And if the member doesn't work at least 5 years after reinstatement, he or she will receive a refund of the contributions made and shall not receive any creditable service. Like I said, reinstatement, rather onerous. You want people to make sure when they retire that they really want to retire. Health insurance. Okay. It's important that soon-to-be retirees know that retirement boards do not handle most health insurance matters. Okay? When people have problems with their health insurance, they're oftentimes likely to call the retirement board with their beef. What I would recommend is it's a good idea to have some phone numbers for the different health insurers handy so that you can refer your members with ease. Affidavit. Every other year, a retiree must sign an affidavit confirming his or her status as a pensioner. There are various reasons, the biggest being that this confirms that the retiree is alive. In this day of direct deposit and joint checking accounts, it's relatively easy for someone to fraudulently cash a deceased retiree's retirement allowance. So you're given 30 days to respond. Okay? If you do not respond to this affidavit within 30 days, your benefit is suspended. Okay? Now, as I mentioned earlier, that suspension, once you're in compliance, you do get your retirement benefit that you missed out. You get a retroactive payment. It differs from the termination. As many of you know, there was pension reform passed in 2011. There were 2 provisions added to address an issue of a member's salary, quote-unquote, spiking just prior to retirement to artificially increase their retirement allowance. So found at Section 14 of Chapter 176 of the Acts of 2011 and Section 18 of those same Acts. John Borak, who is the actuary of the Commonwealth, gave a presentation in 2017 in depth with examples of Section 14 and Section 18. It's available on our website, and I encourage everyone to check it out. But in brief, Section 14, okay, requires that retirement boards must look at the last 5 years of a soon-to-be retiree's creditable service. If the rate of regular compensation more than doubles between 2 consecutive years, then Section 14 is violated. If it is violated, the board must calculate the retirement allowance based on the average of the last 5 years of creditable service, rather than the last 3 years. There are no exceptions. to Section 14. Now, we have a case that's ongoing right now. It concerns a woman who, she worked in the 1990s. Okay, she made approximately $30,000 a year. She went inactive in 1996. Okay. In 2013, she returned, making about $100,000 a year. She worked for 3 years and then retired in 2016. Well, she tripped Section 14 because her salary doubled, more than doubled, between 1996, when she left, and 2013. She argued, however, that 1996 and 2013 are not consecutive, as it's stated in the statute. The Dallas magistrate found that the legislative intent was to prohibit just this sort of scenario, someone popping in and artificially spiking their retirement allowance. It is currently under appeal at CRAV, where PERAC is seeking to enforce the anti-spiking statute. But as I said, it's pending. If we get a decision on that, I'll definitely update this. Section 18. Okay. This requires a board to look at the last 5 years of regular compensation soon-to-be retiree receives. If the regular compensation in any year exceeds the average of the regular comp of the 2 previous years by more than 10%, Section 18 is violated. Okay? So it's not exceed 10% of the previous year, it's exceed 10% of the average of the 2 previous years. Now, for example, for 2019, you need to look at 2017 and 2018 and average out the salaries for those 2 years. Then you multiply that number by 110%. The salary in 2019 must be lower than that figure, or Section 14 is violated. And if it is violated, the regular compensation for 2019 must be reduced to 110% of the 2017-2018 average. There are exceptions to Section 18, unlike Section 14. The exceptions to Section 18, okay, are not violated if the increase is due to any of the following: an increase in hours worked, a bona fide change in position, due to a CBA or union contract negotiations, if it is a salary specified by law. We've come across some salaries that, such as sheriff salaries, that are indeed specified by law. And then there are certain teacher tasks that are accepted as well. Some CBAs and employment agreements contain provisions permitting a member to sell back unused vacation time. Some boards consider the money received to be regular compensation and include it in a retiree's retirement calculation. The recent court decisions, however, have determined that such payments are never regular compensation and should not be used in calculating a retirement allowance. This matter is currently under appeals to the appeals court, but effective November 6, 2018, such payments are not regular compensation. See PERAC memo number 33 of 2018 for instructions going forward. We've also been made aware that even though this matter is pending at the appeals court, legislation is being proposed to perhaps change this. We will keep you posted. Cost of living adjustments. It's important to let soon-to-be retirees know that COLAs are not guaranteed. Okay? They also must know that they must pass the award of a COLA on July 1 before they're eligible for an increase. For example, if a member retires in September of 2018, they need to pass the July 2019 COLA, and then they'd receive their first COLA on July 1, 2020. Domestic relations orders. A retirement allowance is a marital asset. Okay? DROs legally direct a portion of a retirement allowance to be paid to a former spouse. Now, PERAC does not review every DRO, but we do when when boards have specific questions about terms and conditions contained in a DRO, we are willing to opine on that. And remember, it matters who you name and what option you select at the time of retirement. Divorce after does not change who your beneficiary is. And a former spouse who is not remarried is free to remarry after the member's retirement and still receive the benefit. Pension forfeiture. Some people believe that if they've already retired, their pension cannot be forfeited, and that is untrue. Right? There's a situation, a recent case illustrated that. It was a case in which there was a police officer, and while he was a police officer, he confiscated a driver's license. Then he used that driver's license to forge prescriptions for pain-killing medication. He retired, then he continued to use that driver's license to obtain the painkillers. He was arrested and convicted, and although he argued that the crimes had nothing to do with his office or position and that he was a retired police officer, the Court of Appeals found that he obtained the license used to commit the crimes while he was a police officer and a member in service, and therefore his pension should be forfeited. Okay. It's not likely a scenario that comes up often, but just for the global, once you're retired, your pension can still be forfeited. And in conclusion, I just wanted to say that there's no way to prepare for every possible question that a soon-to-be retiree may have, but hopefully this presentation will provide some guidance, and as I said, perhaps you can even direct your soon-to-be retirees to this presentation. And that concludes Chapter 32 in a nutshell presentation. Okay, we do believe that people can send us some questions, but we're having a little bit of difficulty trying to find where those questions may be. Or just maybe no one asked any questions. Oh.
Yeah, there aren't any.
All right, we don't see any questions. We'd like to thank everyone for their attention, and have a nice day.